Okay, Ms. Opalewski, if you could unmute, please. Thank you. Are you able to hear me okay?
I am, Your Honor.
Okay, great. We'll go on the record in Moran versus Torch River Shack LLC. This is a Kalkaska County case number 23-14313. This is set as defendant's motion to compel. It was set for 1:30. It's now slightly after 1:30. And Ms. Opalewski, you're appearing on behalf of defendant Torch River, is that correct?
That's correct, Your Honor. Defendant Torch River Shack Rentals.
Okay. I don't see anybody appearing on behalf of the plaintiff. I did have a chance to review your motion to compel and the supporting documents. I did not get a response, as far as I'm aware of, from the plaintiff or the, no, just the plaintiff. We've got two counsel defending. So is there anything that you wanted to state for the record here today in support of your motion?
Certainly, Your Honor. So to kind of solve a little bit of the mystery here, I did speak with plaintiff's attorney again this morning, and he actually agreed to a stipulated order for the relief that we requested in the motion. So we're going to get that submitted to the court for Your Honor's signature. And also, he did provide the answers to interrogatories after we filed our motion. So it's just for the request, the response to request for production of documents and an authorization that we're still waiting on. So we just weren't able to get a hold of the clerk prior to the hearing today, Your Honor.
Okay. Anything else that we need to address for the record then today?
Your Honor, we will most likely also be submitting a stipulated order for an extension of the scheduling order dates, just because we are getting a lot of these things fairly late in the game here for our current dates. And I know that the other attorneys are agreeable to that. Does Your Honor permit an extension of dates by stipulated order?
Yes.
All right. Thank you, Your Honor. I appreciate it.
Okay, I'll look for that, and you're free to disconnect. Thank you.
Thank you, Your Honor.
Okay, Mr. Cross, are you able to hear me okay?
I can hear you, Judge, yes.
All right, we'll go on the record in B&E Delivery versus Enterprise. This is at SEGO case number 2419665. If I could just have you put your appearance on, Mr. Cross.
Good afternoon, Judge Matthew Cross on behalf of B&E Delivery, Inc.
Thank you. And this is set for hearing today on a motion for default judgment. It was set for hearing at 1:30. It's now 1:35. I do not see anybody on behalf of the defendants appearing today. Is there anything that you wanted to present in support of your motion for default judgment?
No, Judge, I have nothing to add beyond what's in the motion and the proposed default judgment. We did serve Mr. Hook with this motion and notice of hearing, and we've heard nothing either.
Okay. I did have an opportunity to review the file prior to today's hearing along with the motion and supporting documents. It does appear that the defendants were properly served with the summons and complaint in this case. They failed to answer or otherwise defend. Default was entered. They were provided notice of that default as well as notice of the date and time of today's hearing. Again, no one has appeared on behalf of the defendant. And based on the affidavit, the court finds that there's sufficient evidentiary support to enter the judgment as proposed. Mr. Cross, I do have that proposed judgment here. Did you want me to sign that, or were you going to provide a different copy to the court?
You could just sign that copy, Judge.
All right, so I'll enter that today. Anything else I can address for you while we're on the record here?
No, Judge, nothing further from me. Thank you.
Okay, thank you. That's all, and you're free to disconnect at this time.
All right, thank you.
Okay, Mr. Rolla, are you able to hear me okay?
Yeah, Judge, can you hear me?
Yes, thank you.
My apologies. I actually had another matter that I was just advised by Jen now isn't going. So, but in any case, I'm here for the Ryan Walters matter.
Okay, all right. Mr. Walters, are you able to hear me all right?
Yes, sir.
Okay, we're on the record in People versus Walters. This is file number 043019, 053395, and 053396. We have Mr. Rolla here present on behalf of the people. Mr. Walters, this is your application to set aside 3 convictions in this case, and 1 in each of these files. And Mr. Rolla, I did receive your citation to MCL 780.621. And the only question I have, it looks like the 2 breaking and entering with intent felonies that Mr. Walters is asking to have set aside, they do have maximum penalties of 10 years. In my reading of the section you highlighted, says that you can't set aside more than 1 if they're punishable by more than 10 years.
Oh, you're correct, Judge.
Okay, so do you have, go ahead.
I wasn't sure if at the time, and again, if back in 2004 and 2006 they were 10-year felonies, then it doesn't prevent from doing so.
Okay, do you have any other objections to the technical requirements?
No, Your Honor.
Okay, so Mr. Walters, there's 2 other factors that the court has to make findings on. Number 1, the court has to find that your behavior and circumstances since these convictions happened would warrant having them set aside, and that it would be in the public interest to have your convictions set aside. And so you need to give me some reasons as to those 2 factors for why the court should set these aside. So again, your behavior and circumstances since the convictions, and why it would be in the public interest, in other words, in the interest of the entire community to have your convictions set aside. So can you speak to those 2 things for me, please?
Yeah. Ever since my convictions 2004 and 5, I've been in no trouble. Maybe a traffic ticket here and there, but not even really that either. I've had children, I've started a family. I've been trying to find better jobs, basically, is why I wanted to push forward with this, is because I want to get pretty much a good career, so that way I can raise my family and be an upstanding member of the community like I have been. But I haven't been in no trouble since all of those convictions. I've been just pretty much living my life and trying to be a good person, because I was just young at the time. It was basically like a year or 2, not even 2 years, that I just went through a phase, I guess, because I had no criminal record as a juvenile. And then after that, I've had no type of record. I've had no nothing. It was just basically like a bad year and a half, 2 years of my life, pretty much. But I'm just basically trying to get back out there and get a really good job. I applied. I was living in Florida a while ago and applied for Universal Studios. Is what really prompted this, is because I did everything. I got in there. I aced the interview and everything. And then when I went down there for the background check, they said that they had to be 20 years older or something like that. And I didn't end up getting the job. And I had really, really wanted it because, like I said, I was trying to build a future for my family, and doing DoorDash and stuff like that isn't really, it helps, but I want to be somebody out here. You know what I'm saying? I want to be an upstanding member of the community and just be out there, pretty much. And I don't really want this holding me to back on anything anymore, pretty much.
Okay. All right. Thank you. Mr. Rolla, do the people take any position on the relief, ultimately, whether the court should grant?
Judge, I just have one question to clarify the record then, please.
Yes.
Thank you. Now, sir, you indicated that since your convictions of the B&Es and then the narcotics offense, you've had no other involvement other than a traffic ticket. And I want
I'm sorry. Go ahead.
I want to make sure the record's clear. when you had your conviction in March 15th of 2016 for driving on a suspended license, did you think that was just a traffic ticket?
I didn't have any driving on suspendeds. They dropped that down to get my license back, and I was good. So it shouldn't be on the record that I had a driving on suspended. But I
Well-
believe that driving on suspended would be considered a traffic ticket because you're driving.
Okay, the reason I asked is it was included in the documents you filed with the court.
I don't remember filing that document.
It's when you have the check done and the state police runs your record and shows your record.
Yeah.
It did indicate an offense date of March 31st, 2014 in Van Buren Township, and then a conviction date of March 15th, 2016 out of the 34th District Court. I just want to make sure you weren't mistaking anything.
Oh yeah, no, I remember about the driving on suspending, but I don't ever remember, like I said, I really don't remember going to court for that one. I thought you were bringing up a different one that I had gotten taken care of in Lincoln Park, but the
No.
Van Buren one, I didn't remember ever going to court. I remember they gave me the ticket, and then I ended up taking care of the ticket, and nothing was ever about that. So I didn't really remember that. And my wife was helping me do the paperwork. So if it was in the paperwork, I must have missed it.
That's fine. I just wanted the record to be clear on that. So I didn't
Okay.
want the court getting the impression you were trying to provide any false information to the court.
Oh, okay, I got you. Yeah, no, I definitely am not trying to provide any false information.
Nothing further then, Your Honor. Thank you.
Okay. All right, I did have a chance to review all three files as well as the application. The court notes that all the technical requirements were met. The Attorney General's office did not file a response, but they were given an adequate opportunity, which is all that's required. The court finds that Mr. Walters' lack of any substantial criminal history does look like there was that driving issue in 2014, but that's since been set aside as well. Mr. Walters hasn't had any involvement with the criminal justice system. The court also finds that it is in the public interest to the extent that he wants to seek better employment. The court finds that's always in the public interest for individuals who want to seek employment that they're being prevented from being able to get solely by virtue of these convictions, which now are almost, two of them are 20 years old, one of them is almost 20 years old. The court finds that at some point, individuals should be able to move on from that and obtain better employment, and that is in the public interest for people to do that. So the court finds that the grounds have been met. The court will grant the relief requested, and I'm signing that order today, Mr. Walters. So if you want a copy of that for your records, you just need to get in touch with the clerk's office here in Gaylord at the circuit court, okay?
Okay, I'll call them today. Thank you very much.
Okay, thank you. That's all for this hearing. All parties on this case are free to disconnect at this time.
All right, thank
All
you.
right. Thank you. Have a good day, both of you.
Bye now.
Thank you.
Thank you.
Okay, Mr. Blumberg, are you able to hear me okay?
I am.
Okay, great.
I was just actually outside your door, knocking on your door. I don't know if you heard me.
Sorry.
They said no court people there, or no bailiffs, so you can't go in.
Yes, that is correct.
I said, I know this guy. I'm not a danger. No. Apparently my reputation precedes me.
Right, yeah, exactly. We got to have law enforcement around.
I know.
Ms. Bailey, quick, which file are you signing in on?
I am here on the Smith v. Bauer matter.
Oh, okay. I'm going to call that one next, so I'm just going to put you on hold for just a minute. Okay, and Mr. Blumberg, we're here on Boer versus Boer.
Right, Judge. I'm here along with my client, Kendra Boer, the plaintiff.
Okay, and I did have a chance to review the proposed judgment, and I do want to note that we have Mr. Boer also connected. Mr. Boer, can you just unmute, please? Thank you. Are you able to hear me okay, Mr. Boer?
Yes. Yep.
And this is file number 2319356. And Mr. Boer, I see that you have signed the proposed judgment of divorce. Mr. Boer, did you want to proceed with finalizing that today?
Yes, that's correct.
Okay. And Mr. Blumberg, are you ready to take some proofs from your client?
We are. Thank you.
Ms. Boer, if you could raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you. You can lower your hand and please proceed whenever you're ready, Mr. Blumberg.
Thank you. Kendra, could you state your full name for the record?
Kendra Marie Boer.
And you are the plaintiff in this action for divorce, is that correct?
Yes.
And is it true that you filed a complaint for divorce in this county, and in your complaint you allege that on March 28th of 2016 you married Scott Allen Boer in Macomb County, Michigan, is that correct?
Yes.
And that ceremony was performed by an individual who was authorized to perform marriages?
Yes.
At the time that you filed your complaint, you alleged you'd been a resident of the state of Michigan for at least 180 days before you filed, is that correct?
Yes.
And you allege further you'd been a resident of Otsego County for at least 10 days before you filed, is that also correct?
Yes.
You allege that there are no children born in this marriage, is that right?
Yes.
And you are not currently pregnant, is that correct?
That's correct.
You alleged in your complaint that there had been a breakdown of the marriage relationship to the extent that the objects of matrimony had been destroyed, and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed?
Yes.
And is that true today?
Yes.
Now, you and Mr. Boer have come to a property settlement agreement resolving all the property related issues. Is that your understanding?
Yes.
And you have reviewed that separate property settlement agreement that both you and he have reviewed and signed. Is that your understanding?
Yes.
And you understand by the terms of that, you are going to be receiving non-modifiable spousal support paid to you in the sum of $75,000. Is that your understanding?
Yes.
And you are also being awarded the home located here in Otsego County, free and clear of Mr. Boer's interest. Is that your understanding?
Yes.
And he is receiving 3 other properties located in Grand Blanc. Is that your understanding?
Yes.
And again, do you believe that this arrangement, this agreement is both fair and equitable?
Yes.
You understand that each of you are going to receive whatever retirement accounts that you currently possess.
Yes.
And again, the non-modifiability aspect of the spousal support means that the agreement can't be modified, can't be changed going forward. Can't come back at a later date and ask the court for more. And that Mr. Boer cannot come back and ask the court to reduce the amount of support. Is that your understanding?
Yes, it is.
Okay. And again, if the court did not sign this proposed judgment of divorce, is there any likelihood that you and Mr. Boer would reconcile and get back together as husband and wife?
No.
Okay. Are you asking the court then to sign this proposed judgment of divorce?
Yes.
Thank you. Judge, I don't have any other questions.
Thank you. Mr. Bohr, could you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Bohr, have you heard all the questions that Mr. Blumberg asked of Ms. Bohr?
Yes.
Were you able to hear all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No, Your Honor.
Okay, and have you reviewed the proposed judgment and the property settlement agreement?
Yes, I have.
And do you agree to abide by that, including the provisions regarding the payment of spousal support?
Yes, I do.
And do you agree that that would address all the remaining issues and that there remains nothing for the court to decide in the terms of dividing up any assets or debts of the marriage?
Yes, I agree. That's correct.
Thank you. Mr. Blumberg, did you have any questions for Mr. Bohr?
I do not, Judge.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of the parties. The court will grant the divorce. I'm signing that judgment with today's date. Mr. Blumberg, anything else that we can address today on the record for your side?
No, Judge, thank you.
Mr. Bohr, did you have any questions at all?
No, Your Honor.
Okay, thank you. That's all for this case today. All parties on this file are free to disconnect at this time.
Thank you.
Okay, looks like we've got counsel connected. We'll go on the record in Tresha Smith versus Thomas Bauer, case number 2319444. If I could just have counsel put your appearances on, starting with plaintiff, please.
Miranda Bailey Quick on behalf of plaintiff.
Afternoon, Your Honor. Matt Tompkins here for the defendants.
Okay, this is set for a status conference in this file today. I believe the last time we met was back in April. Ms. Bailey Quick, on behalf of plaintiff, can you tell me where things are at from your side, please?
Yep. So I have everything ready to file with the probate court. I reached out via email and phone earlier today, realizing that I just need a proposed full release and discharge from Mr. Tompkins' client in order to file, and that's the last piece I need in order to file with probate court.
Okay, Mr. Tompkins?
That's something we can turn around quickly, Your Honor, next day or two, perhaps given the holiday early next week.
Okay. Ms. Bailey Quick, what's your suggestion for going forward in this file in terms of scheduling?
Perhaps if the court just set it for 60 days, we should have everything good to go. I would think that Judge Cooper would probably have a hearing date before now and then. If we don't have a hearing date before then, I would propose we just simply sign a stip and move it to the next available date.
Okay. Mr. Tompkins, any objection to that?
No objection, Your Honor. I'm just out of curiosity, I'm wondering if Your Honor could preside over the motion for approval and distribution. Given that there's a pending action, I'm wondering if we even need to involve the probate court, just for efficiency's sake.
Yeah, I mean, I you know, aside from that issue, we have a concurrent jurisdiction plan here and the court's cross-assigned with our probate judge. So, I mean, I'd be happy if it's more efficient for the parties to not have to schedule hearings in two different courts. You know, I think from a procedural standpoint and a jurisdictional standpoint, I think I would have the authority to pass on that. So I guess I would leave that to counsel. If you guys want to talk about that, I'd be happy to get you a date if one of you wants to call in, if that's the way the two of you would like to go.
Very
I
good,
guess
Your Honor.
my only question, sorry, go ahead.
Go ahead, I interrupted you.
I guess my only question, judges, is I've never had the court handle it that way. Would you continue to preside over ongoing review hearings in the conservatorship action or just over the motion for approval?
That would just be the approval, and yeah, I wouldn't be taking the assignment of the probate case. It would just be a matter of presiding over that particular hearing for the sake of the convenience of the parties.
Okay.
I'm fine either way. Just as a suggestion, thought maybe that would be more efficient, but.
Well, what I'm going to do is set this for a status conference in 60 days on this file. If the parties want to agree to proceed some other way, then I'll just have one of you submit or contact my office for a notice of hearing.
Very
Okay.
good.
Okay. Ms. Bailey, quick, anything else I can address for your side today?
No, Your Honor, thank you.
Mr. Tompkins.
Have a great holiday weekend, everybody.
Thanks.
Okay, thanks you too.
Thanks, everybody.
Okay, Ms. Goodrich, are you able to hear me okay?
Yes, sir.
Okay, and let's see, Mr. Goodrich, if you can unmute.
Yep, there we go.
Okay, good. All right, we're on the record now in Goodrich versus Goodrich. This is case number 2419640. And we have both parties connected. This is set for a hearing to finalize a judgment of divorce today. Ms. Goodrich, is that how you wanted to proceed?
Correct.
Okay, and Mr. Goodrich, is that how you wanted to proceed as well?
Yes.
Okay, so I'm going to place both of you under oath. I've got some questions that I need to ask each of you. The questions that I'm going to be asking are the questions that I'm required to ask to establish the grounds for divorce under Michigan law. So if you would both please raise your right hands. You both solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes.
Thank you. You can lower your hands. Ms. Goodrich, as the filing party here, most of my initial questions are going to be for you. So you filed a complaint for divorce in this case and you signed that complaint. Is that true?
Yes.
At the time you signed that complaint, had you been a resident of the state of Michigan for at least 180 days?
Yes.
Had you been a resident of Otsego County for at least 10 days?
Yes.
In the proposed judgment of divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony have been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time that you filed the complaint in this case?
Yes.
Does that remain true today?
Yes.
Are there any children under the age of 18 that were born to or adopted by you during the marriage?
No, sir.
Are you currently pregnant?
No.
You are not going to be receiving any alimony or spousal support. Is that correct?
Correct.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that.
Yes.
Okay, and in terms of any assets or debts and division of property, you and Mr. Goodrich have agreed on all of those things. Is that correct?
Yes.
And you don't own any real estate or real property together?
No.
Okay. All right. Mr. Goodrich, have you heard all the questions that I asked Ms. Goodrich?
Yes.
Have you heard all of her answers?
Yes.
Do you have any reason to believe that any of the answers that she gave were untrue?
No.
And you also will not be receiving any alimony or spousal support as part of the divorce. Is that correct?
Yes.
You understand that you would also be waiving that forever and that you would not be able to come back later and ask the court for that?
Yes.
And do you agree that there are no issues remaining regarding the division of any assets or debts of the marriage and that you and Ms. Goodrich have agreed on all of those things?
Yes.
The court finds that the statutory grounds for divorce have been met by the testimony of both parties. Court will sign the judgment of divorce. So as of today's date, the divorce will be final. Ms. Goodrich, you're asking to have your last name changed, is that correct?
Yes, sir.
Okay, so that is in the judgment and so that is also final today. So from today forward, your name will be legally changed and you need to change your identification and other documents, okay?
Yep.
Ms. Goodrich, did you have any questions at all?
No, sir.
Mr. Goodrich, did you have any questions?
No, sir.
Okay, thank you. That concludes this hearing today and you're both free to disconnect at this time.
Thank you.
Thank you.
All right, Mr. Dundon, which case are you appearing on today?
I'm here on the Stockman matter. I
believe I see opposing counsel there, Your Honor.
Got it. Okay, yep, looks like we got everybody connected, so we'll go on the record now. This is Amur Equipment Finance versus Stuckman Tree Service, case number 19661. If I could just have both counsels, starting with plaintiff, put your appearances on.
Good afternoon, Your Honor. Craig Mears on behalf of Amur Equipment Finance.
Good afternoon, Your Honor. Mark Dundon appearing on behalf of defendant Jacob Stuckman.
Okay. This is set for a scheduling conference in this case today. Mr. Mirza, can you just kind of, on behalf of plaintiff, can you tell me where things are at and maybe just what you'd like to see in terms of scheduling going forward?
Yeah, Your Honor, this is kind of a breach of a rather simple breach of a financing agreement for some stump grinder and a wood chipper. The good news is the plaintiff has recovered both pieces of equipment, and both pieces of equipment have been sold. We were initially suing for $154,000 approximately. And the complaint reflects the chipper, the stump grinder sold for the net proceeds were just under or just over $20,000. The deficiency at this point, Your Honor, is about $135,000. I've communicated this with Mr. Dundon and kind of just waiting to see if we can't get the case settled, at least with his client. There are two Stuckmans, both personally guaranteed the financing agreement. Frank Stuckman, the father, lives in Florida. Amur has sent up a default on him for failure to respond to the complaint. Jacob Stuckman, the son, is appearing with counsel, obviously filed an answer. At this point, we don't need a lot of time, I don't think, Your Honor. I was thinking that if we can't get this case resolved, at least as it relates to Jacob Stuckman, that I would file a motion for summary disposition for the balance due and owing.
Okay, Mr. Dundon.
Yes, Your Honor. I apologize. I know the last piece of equipment was repossessed. I apologize if Craig told me it was sold. Sorry, Craig. I didn't.
No problem.
Must admit, but I knew we were waiting on one piece, Your Honor. I made cross claim. I was waiting to find out the total amount and talk to Mr. Mearswood. Other than that, I was debating cross claiming the father because he was kind of running the whole show, but I wasn't sure if it was necessary. So I don't disagree that this does appear to be a contract issue. It doesn't seem to be too complicated. I just have to, see if we can resolve it as to my client. If not, I would cross claim the father. I don't know how much good it would do, but I'd have to do something and then.
Yeah, Mr. Stuckman Sr., sorry, Mark, if I may. He's in Florida, Your Honor. We served him down in Florida. And that second piece of equipment, the grinder, was picked up in Florida. He surrendered it. Thankfully, there was really no resistance there, but the one piece did travel down to Florida and it was recovered down in Florida. So not sure why Mr. Stuckman hasn't responded, but Mr. Dundon and I have been communicating throughout this case from the beginning. And so if in fact we can get something resolved, it would be great. I can, Mr. Dundon is free to file a cross claim against Mr. Stuckman Sr. if that's necessary, but hopefully we can get a resolution. I'll file a motion for default judgment as well. Once that default is entered, the process is a little bit slow. Obviously, we got to send things up through the mail. So just kind of waiting on that, and I'll file a motion for a default judgment as to Mr. Stuckman that will at least resolve Amur's claims against him, at least in perhaps the short term, and maybe in finality as well.
All right. Do you guys want to have the court set a mediation deadline? How do you want to go forward on that?
I think that would be fine. if we can't resolve it, Judge, I think going to mediation might be the catalyst that could get this case resolved. If we can get it resolved sooner rather than later and not spend a lot of money on attorney's fees, I think that would be great. So I'm headed to Japan on Saturday, so I'm going to be a little bit out of pocket for the next couple of weeks. Just if you can take that into consideration, I'd appreciate that.
Okay.
I'm good with everything you just ran down, Your Honor. Craig, do you mind sending me the sale info? I apologize on that.
Sure, yeah.
Okay, thanks.
I'll send it back to you.
Roger.
All right, so what I'm thinking is if we set aside 120 days for discovery with mediation to occur within that period of time, Mr. Dundon, I do want to press you a little bit. If you're going to file a cross claim, I'm going to put in here that needs to be filed within the next 30 days, just because I'd like to get all the pleadings straight before we get too far down the road.
Will do.
So I'm going to put a 30-day limit on adding parties or amending pleadings. And then I'll set this for a status conference at the close of discovery. And we can see where things are at that point. Obviously, if it's mediated or you guys have otherwise resolved it with regard to Jacob by then that'll resolve that part of it. Obviously, Mr. Mirza, to the extent that you need to file additional motions for default judgment or any kind of dispositive motions, you're free to do that at any point, recognizing that we kind of have a bifurcated case here a little bit with regard to how the defendants are proceeding.
Absolutely.
So these deadlines will apply to everybody overall, but certainly, Mr. Mirza, you're free to file those kind of motions whenever necessary or whenever it works with your case. And then we can, again, see where things are at least at that status conference at the close of discovery, and set more scheduling from there.
That sounds good, Your Honor. Will the court be issuing the order?
Yes. Yep, I'll send this out to the both of you, and there's also a process in there for selecting a mediator. If for some reason you guys aren't able to agree on a mediator as well.
Yes, Your Honor. By the way, not that this matters, Judge, but I'm working without an assistant, and Mr. Mearswood did send me the, sorry, I'm just looking back at my email. He did send me the sale information. It's here. Thank you.
Excellent.
Okay. All right. Any other dates I can address for either of you today?
Not for me, Your Honor. Thank you.
No, thank you, Your Honor.
Okay, so I'll send out the scheduling order. I'll also send out a notice of date and time for that status conference at about 120 days out, and everybody's free to disconnect. Thank you.
Thank you, Your Honor. See you, Mark.
Yeah, thanks, Craig.
Okay, whoever's calling on the phone with the last four digits 1584, can you tell me your name, please?
Penny Patrick.
Miss Patrick? Okay. You can just hold on the line for a minute, okay?
Certainly.
Okay, Miss Patrick, are you still there?
Yes, sir.
Okay, Mr. Patrick has not signed in yet, but I see that he has signed the judgment of divorce, which means that we could proceed today without him present. Did you want to go forward with finalizing the divorce today?
Yes, Your Honor.
Okay, can you raise your right hand and let me know once it's raised, please?
It is, sir.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand, and the court notes that this matter is Patrick versus Patrick, case number 2319520. As I've indicated, this hearing was set for 3:30. It's now 3:36, and Mr. Patrick is not present today. Ms. Patrick, you were not the party that filed for divorce in this case. That was Mr. Patrick. Is that correct?
Yes, sir.
Okay. And the file indicates Mr. Patrick filed for divorce in this case back in November of 2023. Back in November of 2023, Ms. Patrick, had you been a resident of the state of Michigan for at least 180 days?
Yes, sir.
And have you been a resident of Otsego County for at least 10 days?
Yes.
In the complaint for divorce, there's a statement that indicates that there's been a breakdown of your marriage relationship such that the objects of matrimony had been destroyed and there remained no reasonable likelihood that the marriage could be preserved. Was that true at the time back in November of 2023?
Yes, it was.
Does that remain true today?
Yes, it does.
Do you and Mr. Patrick have any children under the age of 18 that were born or adopted during the marriage?
No, sir.
Are you currently pregnant?
No, sir.
Okay. And under the judgment of divorce, you would not be receiving any alimony or spousal support. Is that correct?
It is true. I would not.
You understand that you would be waiving that forever and that you would not be able to come back later and ask the court for that?
I do.
And do you agree that the judgment of divorce that you and Mr. Patrick both signed provides for the division of all the assets and debts of the marriage?
It has.
And that includes 4 parcels of real property, 2 of which will go to him and 2 of which will go to you. Is that correct?
That is correct.
Okay. And are you asking the court to grant the divorce on the terms as set forth in that proposed judgment that you signed?
Yes, sir.
Okay. The court finds that the statutory grounds for divorce have been met by the testimony of Ms. Patrick. I will sign that judgment with today's date. That means that the divorce is final as of today's date. And Ms. Patrick, you're asking to have your last name changed. Is that correct?
Yes, sir.
So because the divorce is final today, that means your name will be changed legally going from today forward. So you'll need to make sure that you change your identification and other documents, okay?
Yes, sir. Will I have something to take to these? This is in the judgment that I will receive a copy of.
Correct. Yep. You'll need that judgment of divorce to change those kind of things. They'll want to see that document.
I will do that.
Okay. Do you have any questions at all?
No, sir. Thank you.
Okay, thank you. That's all for today, and you're free to disconnect at this time.
Thank you.
We're hearing it. Okay, are you Stacy German?
I am.
Okay. And, sir, are you Ricardo? You need to unmute, please.
Oh, yes, I am.
Okay, all right, we're on the record now in German versus German. This is case number 2319504. The record should reflect both parties are present here on the record today. Ms. German, this is your motion. You're asking to have the personal protection order in this case terminated. Is that correct?
Yes, it is.
Okay. So I did have a chance to look at your motion. You indicated that you don't feel threatened and that therefore you don't need the personal protection order to remain in place. I'm just going to ask you a couple of questions. This is what I kind of ask in every case where the person who requested the PPO is then asking to have it terminated. Sometimes people will ask to have them terminated for different reasons. You know, sometimes they feel bad about the effect that it's had on the other person, or they feel guilty about it. Sometimes they feel pressured into having it terminated by friends or family, or even by the other person as well. And so, Ms. German, I just want to make sure that you're asking to have this terminated because you don't feel that you need it anymore, and not because you're feeling pressured into it or you know, feeling bad or guilty about it in some way. So you need to speak to that for me, please.
That's correct. I'm not. I'm just requesting that it be terminated.
Okay, have there been changes in circumstances that lead you to not feel that you need this anymore, or what has changed since you got it that leads you to believe you don't need to have it anymore?
So our divorce is final. When I requested the PPO, our life was rough. We were going through a very bad breakup. There was a lot going on. A lot of people were threatened. A lot of people were worried. So I requested the PPO to protect myself and other people as well. However, things have changed. Our divorce is final. Ricardo has gone through the military. He's passed the military successfully, and he has been talking to my lawyer throughout our divorce process. And my lawyer, prior to our divorce, had expressed some, stated that he feels that there's no reason for me to have a PPO. I should not feel threatened, and which I don't. We have friends in common as well. Ricardo and I do. And I truly believe that things are calm. I believe the military made a change in him. And so I don't feel that I have a need to have a PPO.
Okay. All right. Based on what you told me, then I'm satisfied that you're not being pressured into this in any way. You don't appear to me, just by my observations, to be nervous or frightened in any way either. So the court finds it would be appropriate to terminate the personal protection order. And I'm signing that termination here today. So Mr. German, that order will be terminated as of today's date. If either of you would like a copy of that, you can call the clerk's office here in Otsego County and request a copy. Ms. German, do you have any questions at all?
I do not. Nope.
Mr. German, do you have any questions?
No, Your Honor. Appreciate it.
Okay, thank you. That's all for today, and you're both free to disconnect at this time.
All right,
Okay,
thank you.
That also concludes the court's afternoon docket. The court will be in recess until 9 a.m. tomorrow.